Welcome to this video on the Mine Health and Safety Act, focusing on legal liability. This is Video 1, Document XT 1777, Version 4. This video will cover the legislative framework, specifically focusing on the Mine Health and Safety Act. The objectives of this act include correctly interpreting its aspects, ensuring all persons under charge are conversant with its provisions, and enforcing the act, regulations, and codes of practice. The Mine Health and Safety Act arose because the Minerals Act did not sufficiently address health and safety issues. The 1996 Merriespruit disaster led to the Leon Commission, which recommended drafting this dedicated act. The Mine Health and Safety Act is organized into 8 chapters, encompassing a total of 106 sections. The Act aims to protect health and safety at mines, require hazard identification and risk minimization, provide for employee participation and monitoring, enforce safety measures, foster a safety culture, and promote training. To understand the Act's application, we must know key definitions. A working place is any area at the mine where employees travel and work. Mine is defined broadly, covering excavations and infrastructure used for mineral extraction. The term mine as a verb refers to exploiting a mineral for winning it. Prospecting means intentionally looking for a mineral. A mineral is any naturally occurring solid, liquid, or gas substance, excluding water, formed by a geological process. A mining area includes the adjacent area and non-adjacent, connected, continuous areas used in connection with the mine. The key definitions regarding application are crucial for understanding the scope of the MHSA. Works means a place, not a mine, for power distribution, training, or specific subterranean operations. An employer is an owner. An owner is a permit holder, exploiter, or the last person who worked the mine. An employee works at a mine. The standard of care required is based on the reasonable man test. Courts use this hypothetical standard to determine if an employer's actions were reasonable in a given case, involving a value judgment. In the Kruger v. Coetzee case, the court stated that negligence arises if a reasonable person would foresee the possibility of causing injury or loss and would take reasonable steps to guard against it, but the defendant failed to take those steps. The reasonable man evaluation requires asking, did the employee foresee the possibility of damage? If yes, did they take steps to prevent it? If preventative steps could be taken and they failed to do so, they are negligent. Negligence is defined as a failure to comply with the MHSA. If an employee is found guilty, they may be liable to a maximum fine of up to $1 million or 5 years imprisonment. The concept of reasonably practicable moderates the employer's absolute duty to ensure employee safety. Practicable means having regard to the severity of the hazard, available knowledge, suitability of mitigation means, and the cost of removal or mitigation versus the benefits derived. Practicable action must be capable of being done and reasonable. This involves weighing the risk and severity of injury against the overall cost and feasibility of safeguards, considering what is known about the hazard. Cost is not an excuse for failing to provide safeguards, especially where the risk of injury is serious. Common practice and industry knowledge are considered when judging reasonably practicable, meaning employers cannot claim ignorance if safeguards are widely known and used elsewhere. General duties of the employer under Section 2 of the MHSA include ensuring, as far as reasonably practicable, that the mine is designed, constructed, and equipped to provide a safe working environment. They must also ensure the mine is commissioned, operated, maintained, and decommissioned safely. Employers must take reasonable steps to prevent anyone from being exposed to health and safety dangers at a mine that is not worked, but has not yet been issued a closure certificate. This emphasizes ongoing responsibility. Section 5 of the MHSA requires the employer to provide a working environment that is safe and without risk to employee health as far as reasonably practicable. They must also identify hazards and assess risks for non-employees and ensure their safety. Section 7(1)(b) states that the employer must institute necessary measures for health and safety and ensure every employee obeys the MHSA requirements as far as reasonably practicable. Non-compliance by any person can lead to fines or imprisonment. The Act obligates employers to prevent unsafe conditions and ensure compliance with established health and safety measures by all persons on the mine. When persons do not comply, employers must enforce the law. Measures can include counseling, training, or disciplinary action. Disciplinary codes used for enforcement must comply with the principles of the Labor Relations Act. Section 7(1)(e) addresses supervision. A supervisor is typically the lowest level management, responsible for day-to-day performance, guiding the team, ensuring productivity, and resolving problems. A supervisor has experience in the group's work and guides them towards goals. They aim for team productivity and problem resolution. They are typically a step above a lead position but below a manager. Supervision is essential for achieving mine health and safety objectives. Supervision is the management activity where supervisors oversee the productivity and progress of their direct reports. It is a management role with different levels of supervision across the organization. Supervisors play a key role in designing the organization and staff, managing personnel, training employees, performance management, and managing personnel policies. Other duties in Chapter 2 of the MHSA include the role of the mine manager. Section 3 obliges the employer to appoint one or more qualified managers responsible for the day-to-day management of the mine. If multiple managers are appointed, duties must not overlap. If no manager is appointed, the employer performs this function. Appointing a manager does not relieve the employer of their overall MHSA obligations. The employer can assign duties from Sections 2 and 3 to any person, except the manager's role in Section 3. The employer must provide necessary resources and ensure assigned functions are performed. The employer must supply all necessary health and safety equipment to each employee, maintain it, and ensure sufficient quantities are available on site. Employers must prepare a health and safety policy describing the organization, protecting employees and non-employees, and outlining procedures for review. Consultation with the safety committee is required. The policy must be prominently displayed, and health and safety representatives must receive a copy for their records. Regarding codes of practice, the employer may prepare them on any health and safety matter. They must prepare a code of practice when requested by the Chief Inspector of Mines, following provided guidelines. The employer must consult with the Health and Safety Committee on the preparation, implementation, and revision of the code of practice. Employees also have health and safety duties, highlighting the need for employers and employees to work together for good safety management. The most important employee responsibilities include taking reasonable care of their own health and safety, avoiding wearing jewelry or loose clothing near machinery, and securing long hair or headscarves. Employees must also take reasonable care not to endanger others, cooperate with the employer, follow company policies, and not misuse safety equipment. Injuries or illnesses suffered on the job must be reported. Employees must inform their employer if something affects their ability to work, such as pregnancy or injury, so the employer can find solutions. They must also report if medication makes them drowsy, especially when operating machinery. Workers must follow lawful instructions, comply with rules and procedures prescribed by the employer, and wear required personal protective clothing or use safety equipment. The MHSA extends workers' rights, including the right to information. Workers must have access to the Act, regulations, and workplace safety rules, procedures, and standards. Employees can request information about health and safety hazards, precautionary measures, and procedures for hazardous substance exposure. They can also request their private medical practitioner to investigate their medical and exposure records.